Welcome, everybody, to the second panel in the series Eugenic Thinking in Australasia. My name's Rob Wilson, and I'm a professor of philosophy at UWA. The series is sponsored by University of Western Australia and organised by Jane Lydon, my colleague in history, and myself, and also by the not-for-profit organisation Philosophical Engagement in Public Life, or PEOPLE, which we've set up here based in Perth, and also by the Australasian Association of Philosophy. So we're really pleased to be continuing this series, second of three. I'm going to hand you over to Lucia Necco.
I'm going to present you the chair for this panel, which is Ruth Balint.
Hi, everybody, and thank you, Lucia and Rob, for that introduction. I just want to say I'm really delighted to be chairing this session, to have been invited by Jane Lydon and Rob Wilson to chair this session, and of three such inspiring scholars in this field. Before I begin, I'd like to acknowledge that I'm speaking from the traditional lands of the Gadigal people, from the traditional lands of the Gadigal people of the Eora Nation, and I pay my respect to elders past and present. I've also been given this opportunity to do a short introduction, a little like Jane did last week. And I thought I would just talk a little bit about my own work in this field. So in my own work, I've identified two main threads that connect apparently disconnected histories. The first is the ongoing presence of a eugenics or biopolitics of the border, manifested in the regulation of immigration. In fact, it makes sense to speak of an emerging international biopolitics of the border in this period, as scholars such as Alison Bashford and Stephen Garton have done. Eugenics is often associated with the practice of breeding and reproduction, but in fact had wider reaching implications to do with the calculated management of the quality of the population, so that immigration became a key site for controlling the movement of people through a eugenic logic. This manifested in migration selection processes in the displaced persons camps after World War II, for example, where refugees in Europe were selected for resettlement in Western countries according to their racial and physical fitness. No country was prepared to admit Holocaust survivors on an open basis, and certainly not Australia. Fitness for labour was the primary criterion, and any outward physical or mental evidence of suffering and persecution was a disincentive. In fact, in reference to Joanne Faulkner's comment last week about beautiful bodies, I was reminded of Harold Grant, a migrant selection officer stationed in Germany, who in an oral history recalled that choosing suitable candidates for Australian migration was governed by a kind of pub test. They had to look like, and this is a quote, people that you and I could consort with on Bondi because of the Bondi Lifesaver, as we wanted to make out about the beautiful bolts. These were people less physically attractive than the ordinary displaced persons. You could see that from what they'd been through, end quote. My second argument is that an entrenched practice in Western societies of segregating those considered abnormal from the rest of normal society persisted in this period. There was considerable pressure placed on families to relinquish their disabled child for the good of the child, for themselves and their other children, and to place them in the hands of the expert, for whom the institution, rather than the family home, was considered the disabled child's proper place. So that while the history of the post-war period is being revised as an important juncture in the development of a new ideology of humanitarianism and welfare, the experiences of families of disabled children suggest that utopian theories of human rehabilitation were not all-encompassing. Rather, they were underpinned and informed by older ideas about which children were entitled to be future citizens and which were not. Seen through the lens of the refugee family, these two histories, one of immigration and one of institutionalisation, are evidence of continuities in ideology and practice rather than of change in the aftermath of World War II. The rupture of families is one that binds these histories together. It is also a link, I think, to the history discussed in last week's panel on Aboriginal experiences of eugenic thinking, and we'll be hearing a bit more about that today. Lastly, this history persists. Despite international commitments to instruments of tolerance, refugees and migrants with disabilities remain the most unwanted of immigrants. Australia has done little to change or ameliorate the restrictions towards disability in immigration policy. In 1957, when the Migration Act in Australia was amended to remove restrictions based on race, the health clause excluding people with disabilities remained. Today, despite the enactment of the Disability Discrimination Act in 1992 and the ratification of the UN Convention on the Rights of Persons with Disabilities, the Australian government has ensured that the Migration Act remains exempt from the Australian Disability Discrimination Act, making immigration one area of government policy quarantined from these instruments of tolerance. Children suffer the most from this. Australia's immigration laws require all migrants to prove they will not be a burden on the community. Refugee and temporary migrant families with a disabled child regularly face deportation or separation. Interesting to note, actually, that Canada repealed its legislation recently for the similar legislation for humanitarian reasons. An irony in all of this is that while Australia is actively excluding those classified as a burden because of their disability, it is also actively disabling people by its policies of offshore detention of asylum seekers. I will now turn to introducing the first of our speakers today. Dr. Luara Ferracioli is Senior Lecturer in Political Philosophy at the University of Sydney. She was awarded her PhD from the Australian National University and was a Global Leaders Fellow at Oxford and Princeton in 2011 to 2013. Prior to her appointment at the University of Sydney, she was an Assistant Professor in Political Theory at the University of Amsterdam. In 2021, between 2021 to 2022, she will be a Lawrence S. Rockefeller Fellow at Princeton. Her book, Liberal Self-Determination in a World of Migration, will be published with Oxford University Press in December of this year. So Luara, I'd like to hand the panel over to you to start.
Thank you so much, Ruth and Rob. Thanks for having me. Let me just share my screen. All right. So I wanted to start by acknowledging the Darul speaking people, who are the traditional custodians of the land where I live in the Southern Shire. And today the presentation will be part of the book that Ruth, it's part of the work I did for this book that Ruth mentioned. And in this chapter, really you're getting a chapter of the book, I explain why states have a right to control their borders, why justice does not require open borders, but I try and develop an account of the state's right to exclude that closes the door for racism in immigration. So that's the connection with today's panel. All right. So all of those who are familiar with the philosophy of immigration would know this quote from Joseph Cairns really well, where he says that like feudal birthright privileges, restrictive citizenship is hard to justify when one thinks about it closely. So Cairns is the most famous proponent of open borders. Back in 1987, he really put pressure on the idea that states have a right to control their borders. And he did that by putting forward 3 arguments in favor of open borders: a libertarian argument, a utilitarian argument, and a liberal argument. Today, I'm only interested in the liberal argument because I'm working within the liberal tradition. And I do think, unlike the other 2 arguments, which really lead us to open borders, I think there is a way to remain liberal, committed to liberalism, whilst not endorsing open borders as an ideal. Now, just quickly, for those who are in favor of open borders, I'm not here to justify the immigration arrangements that liberal states have in place. I'm just going to justify their moral right to control their borders. But the main thing I do in the book is to show that this moral right is quite limited in scope, and that there are all sorts of moral obligations that states have both towards members and non-members that constrains the scope of that right, such that a just migration regime looks quite different from the migration regimes we have in liberal societies right now. So Karen's going back to this challenge that Karen's puts forward. The idea, the concern there is this: if we care so much about freedom and equality, how can we have an international arrangement where people are not treated as equals? They can't use migration to make use of the opportunities that those in the global north make use of. And how can we take seriously our commitment to freedom if we're preventing people from moving abroad and pursuing whatever life plan they would like to pursue in other parts of the world? So really, this is the challenge. And together with that challenge, there is a challenge coming from those who are concerned with discrimination and how immigration control has this terrible history of being used for racist purposes. And Sarah Fine has a very good quote where she says, "The shameful history of immigration controls has led some philosophers, commentators, and activists to conclude that such controls are inherently, inexorably racist. They had racist beginnings and continue, directly and indirectly, to promote or permit racist ends." So connected to this liberal challenge, there is this discrimination challenge, which is, even if we can tell some story that explain why states have a moral right to control their borders, what criteria could the liberal state permissibly use when it makes policy decisions in the area of migration, given that there's always a danger that they're going to use their right to control their borders to promote racist ends? Now, there are many accounts out there that aim at explaining why we can still remain committed to liberalism without having to go for open borders. The four really most famous accounts have been put forward by Wellman, Miller, Pavnik, and Blake. Just quickly, the idea, the kind of key arguments on the part of each one of them goes as follows. For Wellman, states have a right to control their borders because political communities have a right to freedom of association. And so in the same way that a state should be able to say, Australia should be able to choose whether it wants to enter into a regional association with New Zealand, for example, it should be able to decide whether it wants to open their borders to non-members, to foreigners, people who have been born overseas. Miller talks about the importance of protecting the political culture of institutions, and argues that immigration plays an important role in that. There's some question mark around whether Miller counts as a so-called liberal partialist, but we don't need to get into that here. Pavnik talks about the importance of citizens retaining their ownership, arguing that citizens are owners of their public institutions, and the immigration plays an important role in sustaining that arrangement. It's just a kind of standard story about ownership. When you own something, you have the right to exclude others. So citizens have a right to exclude non-citizens from joining in. And Blake argues that we all have a right to avoid incurring human rights obligations when people have their human rights protected abroad, and yet they want to join our community, they're imposing that obligation on us, even though they can have their human rights protected elsewhere. Now, of course, not everyone has their human rights protected abroad, and Blake accepts that. And of course, then that right won't apply to such persons. They will count as refugees and citizens who have an obligation to open their borders to these people who have their human rights violated abroad. So if you think about all these different stories that justify the state's right to exclude, you can see that they open the door for problematic forms of discrimination. There's nothing about these theories that rules out an immigration arrangement that is kind of, inherently racist. Why? Because it's up to the community whether it wants to associate with this ethnic group or not, or wants to protect the community from cultural change that would be brought about by an ethnic group or racialized group, or with the ownership of institutions. Usually when you exclude someone from entering your house, it's up to you why you're excluding people. You don't have to open your borders to people from who belong to racialized groups. And the same thing with Blake's account, that so long as groups who have been racialized, or ethnic groups, can have their human rights protected abroad, then there is no obligation to take them in. So you can see that all the stories have been developed to respond to the challenge that Joe Cairns has put forward back in 1987, have this problem of still allowing problematic forms of discrimination in immigration policy. And of course, if we tell prospective immigrants that they cannot enjoy greater personal freedom or opportunities due to factors that are politically relevant, we are treating them in ways liberals deem unacceptable. So those liberal accounts allow for problematic forms of discrimination, but at the same time, there's a tension there because liberalism is not, is often used as a way, gives you the theoretical, often gives you the theoretical resources to avoid a situation where people are denied opportunities or freedom due to politically relevant factors. Okay. So there's always a potential response on the part of liberals, which is to say, yes, okay, our accounts of why states have a right to control their borders does not preclude problematic forms of discrimination, but we're really not in the business of making the world a better place. It's unfortunate that some people are going to be denied the benefit of immigration due to, say, racism or sexism, but they were never entitled to the benefit in the first place, right? So that's one response available to the liberal. They can say, we have to include refugees, but if someone else is excluded for problematic reasons, well, we have to live with that because we're not in the business of making the world a better place. We're in the business of realizing the values of freedom and equality, but most importantly, when we're thinking of, say, the right of states to control their borders, we are in the business of giving them control over their political future, and that their picture of their ideal political future is not going to satisfy everyone from all corners of the world. One concern with that response is that it's not just about the opportunity costs to the migrants. It's also about how discrimination undermines the liberal character of the state. So even putting the issue of opportunity costs aside and accepting that once you've included refugees, you are, you don't have a duty to open up opportunities for everyone. There's still something quite uncomfortable about a liberal theory of immigration that allows states to implement migration arrangements that discriminate on the basis of, say, race or sex. So really the challenge is this: liberal partialists must provide a liberal theory of immigration that rules out discriminatory immigration arrangements without subscribing to the position that justice requires open borders. This means standing up for the values of freedom and equality without going as far as to completely erase the political difference between citizens and non-citizens. Because if you don't erase that difference, then you are in the domain of open borders. And of course, you can push for that. But if you are someone like me who is not convinced that justice requires open border, but is convinced that we need to realize the values of freedom and equality, then you need to develop a theory that rules out discriminatory immigration policy, racist immigration policies. So this is what I'm doing in this chapter, and giving you, I can't go over everything, but the key argument that I put forward in the chapter I mentioned. So there is a kind of standard story out there that tries to, that liberal partialists appeal to when they try and avoid the implication that they are kind of opening the door for racist immigration policies. And that story appeals to insult. So either we can't have racist immigration policies in liberal societies, because either we'll be insulting those prospective immigrants, we're telling those immigrants prospective immigrants we are not including, or we're insulting those citizens who share aspects of their identity, right? So either we're insulting, say, someone who belongs to a racialized group abroad, when we say, look, we're not going to include you, your membership here is not part of this political future we are pursuing, or we're insulting the citizens who are part of that racialized group by saying, oh, there's something about you that we are not happy about, and we're using as a way of excluding prospective immigrants from entering our society. Now, I think there's something to those stories, but they have many problems. And I don't have time to go into all of the concerns right now, but it's something you can ask me when we have a discussion later on. But even leaving the kind of objections that you could raise against that story, there's a kind of broader concern about how insult sometimes won't explain why an immigration arrangement is morally problematic, or where there will also be cases where people might rightly feel insulted, and yet we still think states are allowed to exclude them. So in the first example here, I have a state that excludes people who are older than 50 from applying to their skilled migration program. And as a result, both elderly prospective immigrants and citizens feel insulted. But if we think that skilled migration regimes can be justified because of the economic contribution of the migrants, then it's regrettable that some people might feel insulted, but it doesn't seem like the insult can do the work of showing that these are unjust arrangements. And also, you might think of an arrangement where a state closes its borders to skilled immigrants despite needing those immigrants. And of course, when everyone is denied an opportunity, it's not clear that anyone is allowed to feel insulted, given that no one was given that opportunity. So no one is allowed to feel insulted for not having access to an opportunity that no one is being given, no one is accessing. And so, but still, you might think that this is a problematic immigration policy because it's harming future the future members of society, those who will pay the cost of an immigration policy that has quite negative effects. So in other words, the lessons really are that disrespect doesn't exhaust the moral cost of an immigration policy. And also the second lesson is that it is illegitimate for a self-determining political community to make a decision in immigration that will harm members who are not yet in a position to take part in collective decision-making. And that's true irrespective of whether someone is feeling insulted. So I think states have a right to exclude due to the value of liberal self-determination. It's not just any form of self-determination. It's self-determination that aims at realizing the values of freedom and equality in a way that is in line with the history of a country, the kind of natural resources, the institutions, etc. And so there's a valuable connection between the political rights and duties held and borne by citizens of a liberal state and a particular liberal political project that they instantiate when they go about exercising such rights and duties in the course of their adult life. So liberal self-determination is valuable because people care deeply about how their communities evolve, but that doesn't mean they can pursue any project. A liberal political project should be ultimately in the business of realizing those values, even though there's some room for experimentation because different political communities have different history, public institutions, natural resources, etc. So, but it's important, and just I want to flag that when citizens are in the business of pursuing this future, they should both care about its effectiveness. So we want to bring about, implement arrangements that will do the job of realizing those values, but we also want arrangements that will render them stable so that once we reach that point, it's not easy to disrupt them. And that has also has implications for immigration arrangements. So although there is a lot of misguided rhetoric in public debate over immigration that focuses on the immigrants' negative effects on culture and identity, I think there is a point in the vicinity that must be taken seriously. Immigration affects the liberal project of a state to a significant degree. And it is for these reasons that citizens should have some degree of control over what sort of immigration arrangements are to be pursued and implemented. But because we are in the business, ultimately in the business of realizing those values in a particular political community, some forms, some arrangements, both in immigration and in other aspects of, in other areas, are kind of ruled out at the level of justification because they in no way puts us in a position to realize those values. So when we implement racist immigration arrangements, we are moving further away from that ideal where the freedoms, the values of freedom and equality are realized. And so that just doesn't belong to it's not part of the repertoire that's available to a liberal community. And that's how you can justify the state's right to exclude by appealing to the value of political self-determination without opening the door for racist immigration policies, because there's no way in which those policies will put us in a position to realize those values. If anything, they'll make it much harder for us to create and maintain a society that ensures that people stand as free and equals. And that's me. Thank you.
Thank you very much, Luara. That was a fascinating paper. I just want to remind people that you can drop questions into the Q&A section. You'll see a button at the bottom of your screen. The three speakers have decided that the format they'd like to follow is to have one paper after another, and then we'll open up for questions. So please do put your questions in the Q&A section. The next paper we have is from Matt Lister. Matt is a lawyer and philosopher who teaches migration and refugee law and workplace law at Deakin University Law School in Melbourne. Before coming to Deakin, he taught in the Legal Studies Department at the Wharton School of Business at Penn Law, Villanova Law School, and the University of Denver School of Law, and was a law clerk on the Court of Appeals for the Third Circuit and the US Court of International Trade. He has a PhD in philosophy from the University of Pennsylvania and has published on several aspects of immigration and refugee law and policy, as well as political and legal philosophy more generally. Before starting his graduate studies at Penn, he was a US Peace Corps volunteer in Russia for 2 years. Matt, over to you. Thank you.
Thank you. Let me see if I can share my screen here, if I get the right bit. There we go. So I want to thank Rob and Ruth for having me here today. And my talk is going to be on the idea of undesirable aliens. So pretty much all states that have immigration, and as long as states have been trying to control immigration, there has been an idea that certain aliens are undesirable and states have wanted to keep them out. There is, of course, variation found among states, but especially in states that have significant amounts of immigration, this has been a common feature. The goals to my talk today is to categorize these types of undesirable aliens that states have wanted to regulate, look at the origins of these regulations, their basis, purported justifications for them, possible defenses of them, and restriction and criticisms of the restrictions that we might make. Now, one thing to note right away is that these types of restrictions have had a connection with racial or ethnic classifications. I'm not going to talk specifically about racial or ethnic classifications today, since Luara already talked about those, but these have had a connection with them. One of the ways that this was done early on was that some races were seen as prone to have these types of undesirable characteristics or to be carriers of the undesirable traits. So in the US, when Chinese migration was restricted in the 1880s and later, one of the reasons why this was done was because Chinese people were thought to be inherently criminal, or Chinese women were prone to be prostitutes. When migration from Southern Europe was restricted or debated, one of the ideas that came up a lot was the idea that Southern people from Europe were less intelligent or more likely to be feeble-minded, or more likely to be criminal than people from Northern Europe. Now, right from the start, people knew that these traits were conceptually distinct from racial traits, and because of that, they were all also legally distinct. So there would be restrictions based on various types of traits seen as undesirable and racial traits. So people knew that not all Chinese people were criminals and not all criminals were Chinese, so they would have distinction, both of these things put up. Nonetheless, they were often tied together. Now, these days, very few, if any, states have explicit racial restrictions on or prohibitions on migration. Some states have rules that make it easier if you're from a particular background or give you certain benefits, but very few have explicit restrictions. Now, nonetheless, these types of restrictions on undesirable aliens remain, and that's worth thinking about for us. So we see that they remain despite the relative demise of racial restrictions. And they haven't been given as much discussion or thought in the philosophical literature, which is interesting for me as well. So all of these undesirable traits are thought to pose a danger to the receiving state in various ways. And we can break these down in a couple of different ways. So they're thought to provide a danger to the physical safety of the society, to the health of the population, to the fiscal or economic well-being of the society, or to the morals of the society. So all of these traits are designed to prevent one of these types of dangers. Now, one question for us to consider is how far these restrictions relate to behaviors of individuals. And these are behaviors that would be at least purportedly voluntary. So people could not engage in the undesired behavior if they want to migrate, or they could remedy the situation, or how far these types of restrictions are about types of people. And if they're about types of people, then it's much harder to change it, and that should give us more reason to be a little bit worried about them. Now, early version of the restrictions seemed to be more put in terms of types of people, not completely, but more in terms of types of people, while later versions are more put in terms of behavior or things about somebody that might be changed or modified. I'm going to suggest that this is at least somewhat misleading. And we can ask if we should care about this if it's so, and I'm going to suggest we should care about it insofar it's so. Now let's look at some of the early types of undesirable aliens. When you look at the US, when you look at early immigration regulations, things were put in place to stop vagrants and paupers, prostitutes, convicts, lunatics, idiots, those likely to be of public charges, people suffering from contagious or loathsome diseases. Those are, I think, mostly sexually transmitted diseases. If you look at Australia, there were early regulations put in place to stop criminals, anarchists, public enemies, hotbeds of disease, and sexually immoral women. Australia also had the benefit from some perspective that it had a sort of all-purpose tool, the so-called dictation test, that could be whipped out and used in a sort of capricious or lawless way to exclude anybody that was thought to be undesirable, even if it wasn't written specifically for them. Now, contemporary undesirable alien categories can be put, I think, under 4 broad headings. And these cut up in different ways, a little bit in different societies. They're a little bit cross-cutting, but I think it's still useful for us to see them as falling into 4 main categories. So we have regulations of public health, ones about access to public resources or funds, ones relating to public safety, where this includes both crime and public order, and regulations about national security. Now, I'm not going to talk about the national security ones. There's at least some of the same sorts of worries can come up in relation to the national security issues, but I think that they're conceptually distinct enough that it's worth leaving those ones aside and focusing more on the first 3. So that's what I'm going to do. Let's start with the idea of public health. Now, the public health regulations on their face seem like they're easy to justify. Public health seems like something everybody's in favor of, but there are some worries. Now, these are traditionally mostly directed at communicable diseases, but sometimes this is done in a way that is at least somewhat dubious. I'll talk about this more in a minute, but one example of this is the way that people who are HIV positive have been treated in the US and in a slightly different way in Australia. And sometimes you get really weird things included in these categories that are hard to understand as public health, even though that's the category they're put in. So sometimes there have been restrictions on people with dangerous mental illnesses included in this category, even though, of course, a mental illness is not a public health issue in anything like the same sort of way that a communicable disease, Ebola or something might be, or tuberculosis might be seen as. Now, again, generally these on their face seem like they'd be easy to justify, but there's some possible worries about them. So one is that the rules for testing them vary depending on what country you come from. And again, on its face, that seems like it might be not a big problem. You might think that the risk of having different types of communicable diseases also varies on what country you're from. But these rules tend to be applied in a quite mechanical, unspecified way. And that itself can be problematic. And you can, just for an example of this, when my wife and I came to Australia from the US a little more than 4 years ago, we were on temporary work visas at the time. And because of that, I had essentially no health inspection. I had to attest that I was healthy. But because my wife is from Russia originally, she had to have a rather expensive medical examination, including a chest x-ray purporting to test for tuberculosis before she could get a visa. And that was so even though she'd been living in the US for 15 years before that. Because she was originally from Russia, she had to get this, was applied pretty mechanically. That can be problematic. Sometimes the rules seem to depend more on stereotype than fact, and they can apply to people that don't impose any sort of general danger. And again, here we can see this with some of the restrictions on people with certain sexually transmitted diseases, and especially HIV. Now, of course, HIV is contagious in one sense, but not in the sense that we normally think of public health restrictions to prevent. You can be around HIV positive people and never ever get sick, at least the vast majority of the time. Nonetheless, people who are HIV positive were flatly excluded from the US for many years and were effectively excluded from Australia for a long time, and still have difficulty, although perhaps not as much. That seems to me to be based on stereotypes and fear, not on actual need to protect public health. The next category is use of public funds, or so-called fiscal concern. Now, in the US, this is put in terms of someone being likely to be a public charge. And this comes into effect in 2 main ways. One is a rather mechanical one when you want to sponsor a family member to come and visit or to come and live with you. You have to meet certain requirements. They're relatively easy to meet in the US, perhaps in part related to the relative stingy welfare system in the US. Now, there also is a somewhat more problematic aspect, which is that either a consular officer or a person at the border can refuse to grant a visa or admit someone who they think is likely to be a public charge, more or less on their own opinion. And again, there's lots of opportunities for exercising prejudice and discrimination in these cases, and it's really hard to appeal that. Now, in Australia, there's a more systematic and formal system, a few different aspects. I'm going to have to leave lots of nuance out here and in other cases as well. But you can be excluded from receiving a visa if you are thought to be, or if you're likely to impose significant cost or use significant health care if you are admitted. If you are expected to need access to community services, including like special education, special training, home health services or the like. This goes very much to the types of cases Ruth was mentioning. It heavily harms disabled people who would migrate to Australia. If you would impose an undue cost or cause undue prejudice to Australians in terms of access to health care, and the undue prejudice comes in the case where there is a waiting time to receive certain types of healthcare in Australia. So a clear example is there's a waiting list to receive a heart transplant. Because of that, if you're the sort of person who needs a heart transplant, you can't get a visa to come to Australia because the idea that this would impose an undue prejudice on access to healthcare. And this is all made more difficult for people by the so-called one fail, all fail rule. This is a rule that says, imagine there's a family of people who want to migrate to Australia. And one member of this family is disabled, either physically or mentally disabled. In such a case, the whole family will be denied visas. And this will be so even if looking at them as a family, you wouldn't expect them to pose any undue cost because they will be contributors overall. Maybe the family is ready and able to provide most of the help for the person who's disabled. Nonetheless, each person is looked at an individual, and if any member of the family would raise any of these concerns I mentioned, that everyone is refused a visa. It can be quite a harsh rule, cause lots of problems for people. You can find lots of sad stories relating to it. Now, again, as Ruth had mentioned to a degree, these rules make it very difficult for people with any sort of serious disability or health condition to migrate to Australia, even if they don't pose any sort of a danger. So it's not just like dangerous diseases that are prevented. It's people with all sorts of disabilities or injuries. Sometimes you can come as a temporary resident, but you're pretty much prohibited from coming as a permanent resident. Let's look at crime. So pretty much all societies have rules to regulate criminal aliens or others who are seen as a threat to public safety. This seems pretty reasonable on its face, but I'm going to raise a few concerns. Now, these concerns come up both in the application and in principle. I'm going to focus more on the ones in principle. It's also worth noting that the criminal grounds are ones that function both as exclusion grounds and removal grounds. So there are reasons for refusing to grant someone a visa in the first place, but perhaps more problematic, there are also reasons for removing people. So people who are even long-term residents who may have citizen relatives, Australian citizen relatives, can be removed on these grounds. In the US, these fall into a couple of different categories. So they're so-called crimes involving moral turpitude. Now, this category is undefined in the law. It's a sort of old-fashioned common law idea. Like lots of undefined things, it raises a lot of problems. It includes both nasty violent crimes, murder, rape, aggravated assault, but also crimes involving deception or deceit. So you could get under here for serious check fraud or serious credit card fraud. You could fall into this. The next category is aggravated felonies, which sounds again like it's very serious, but it actually includes a lot of crimes that are not necessarily very serious, or at least we wouldn't necessarily think of as being especially serious. Aggravated drunk driving has been found to fall into this. Some crimes that are misdemeanors have been found to be aggravated felonies, weirdly enough. Drug crimes are a big issue. If you've been convicted of almost any drug crime, or if you are a drug addict, you can be removed from the US. There's one small exception for less than 30 grams of marijuana for your own personal use, but otherwise, almost any drug crime fits under here. And then crimes of domestic violence have their own special category. Now in Australia, these are usually put in terms of whether the person has bad character or not, at least these days put in terms of bad character. We apply the so-called character test. This allows for either refusing or canceling the visa of a non-citizen. There's lots of discretion here. We ask whether the relevant minister reasonably suspects that the person would not pass the character test. In these cases, we're supposed to look at the public interest and weigh that against the interest of the alien in deciding whether to remove them. Now, a person is deemed to be of bad character if any of the following applies. They have a substantial criminal record. That means basically that they've been sentenced to 1 year more in jail, a drug rehabilitation facility, or a mental institution. If they associate with persons reasonably believed to be involved in crime, they have a past or present criminal or general conduct that is bad, or there's a significant risk of engaging in certain sorts of bad conduct. Now, again, on their face, these all seem plausible. All of these types of restrictions on undesirable aliens seem plausible. They are protecting legitimate public interests in fiscal responsibility, health, or safety, but I think there's some reasons to worry about them. One is that these rules, as I mentioned, have somewhat dubious origins, connections to racism, to eugenic thinking, to bad stereotypes and other generalizations. There's also problems in their application of the rules. I'm not going to talk about those, although they're pretty important. And there's also what I call deeper, fundamental, or in-principle concerns. I'm going to talk about the first and the third. So dubious origins. I say, should the fact that these categories were historically connected with racist, eugenics-based thinking, or otherwise bad restrictions make us question them? And I think yes, but only to a degree. It should make us nervous about them. It should make us wonder whether we're still motivated in these bad ways. But I think that it shouldn't make us necessarily decide that these are wrong, because a good rule can come about for bad reasons. We can reach good ends, even though we started from a bad spot. But it should make us hesitant about them. It should make us question them and look at them very carefully. The more fundamental worries, we can say, for each of these categories, there are current citizens with the similar traits. Does this give us a ground to worry about them? And also, we should worry about whether these categories essentialize people in some problematic ways. To look at the first one, we're going to look at these very briefly. Many current citizens have the traits that we use to justify either denying or revoking a visa. Is that worry that this treats the citizens in bad ways? We could worry about whether this is insulting or disrespectful. Now, Luara touched on this a little bit. I think that there's something to that, especially when it's done by the state. But we can also worry that it's indicative of a society that doesn't properly value all members. So excluding disabled people might help us think that the society doesn't properly value disabled people. I'm still thinking through these ideas. I'm not sure about them myself, but I think that's a potential line of worry. I think we can also worry about essentializing here. When we look at the crime-related grounds, we see that when a citizen commits a crime, after a certain point, we release them and try to return them to society. But with an alien, we don't do this. We treat them as once a criminal, always a criminal. You might think that we treat them as essentially criminal, essentially dangerous, and this is problematic. These are reasons to worry about these types of restrictions, not just in their application, although there's lots of reason to worry about their application. Whether it means that we should get rid of them altogether or not is something that I'm at least quite unsure of, but I do think it gives us strong grounds to reinvestigate these types of restrictions, see whether they're justified and what justifies them. Thank you.
Thank you very much, Matt. That was a really interesting paper, and I'm sure there'll be lots of grounds for discussion afterwards. But now I'll go to our final paper in this panel, and that is Tim Calabria. Tim is a PhD candidate at La Trobe University, where his research focuses on institutionalised childhoods and colonialism. Tim was awarded a Norman McCahon Scholarship by the National Library of Australia in 2021. Since 2020, Tim has taught history and Aboriginal studies at La Trobe. He's also worked for the First Nations Legal and Research Services as a consulting historian. His recent and forthcoming peer-reviewed journal articles appear in Law and History and History Australia. His research has received the Francis Forbes Prize, the Theory, Race and Colonialism Essay Award, and the Richard Broome Prize. Tim, thank you.
Thanks very much, Ruth. And apologies, I was supposed to go first because I have a kind of earlier historical case, but I was really having some technical difficulties. So can I confirm, Ruth, you can't see my notes? We're all good. Wonderful. Thank you for that.
Yep, we're
fantastic.
all good.
Oh, thank you. Thank you for such a great introduction. I'd like to acknowledge the Wurundjeri and Bunurong elders, past, present, and future, who never ceded sovereignty to the lands that I live and work on. Okay. On the 21st of January, 1913, 13 young boys stepped off the Australian and onto Fremantle's Victoria Quay, where they were greeted by Kingsley Fairbridge. They'd been aboard the passenger liner for 6 weeks on the journey from England to Western Australia. And by the time of their arrival, according to Fairbridge's young wife, the children were sunburnt and dishevelled, steeped in the stench of ill-fitting cheap suits which they'd worn indiscriminately on board ship. The children's arrival in Western Australia was the culmination of years of campaigning by Kingsley Fairbridge, who welcomed these as the first to be institutionalised at his new farm school. He'd been advocating since 1908 for a formal child migration program, which would take poor urban children as young as possible from Britain and educate them for agriculture in the colonies. At the institution, Fairbridge sought to make the children into, quote, patriotic and self-reliant citizens who would be not only in the country, but of the country. Okay, there we go. This was far from the first social engineering program in Australia, and it was also far from the first British child migration scheme. In 1618, a group of poor young children left Britain for Virginia in the US or in the Americas. And over the following 3.5 centuries, over 100,000 children would be sent from the metropole to populate the British Empire. The Fairbridge scheme was one of many such programs that systematically sent disadvantaged children to live overseas in the heyday of British settler colonialism. So in this paper, I argue that the Fairbridge scheme represented a distinctive eugenicist intervention, which responded to the lack of rural occupiers in Western Australia by introducing British children as future settlers. The scheme was an attempt to systematically exclude the person that each institutionalised child was going to become, or would have become had they not been taken, more often than not, from their families and sent to become colonists. Today, I'm going to start by drawing on a lineage of ideas about subjectivity and childhood from continental philosophy, not only to situate the personal and social impacts of the Fairbridge scheme, but also to speak to wider processes of indoctrination relevant to a lot of examples beyond this narrow case, including the stolen generations institutions in this period. For this reason, I'll spend a bit of time on that. Then I'm going to explore Kingsley Fairbridge's specific intentions for the institution and focus on its functions from the school's opening in 1913 until Kingsley Fairbridge's death in 1924. He wrote a lot about what he intended and why, so I'm able to draw directly from Fairbridge's speeches, articles, correspondences, and codes of conduct to detail how he sought to determine the identities of the children, such that they'd become the ideal British agrarian colonisers that circumstances in southwest Western Australia demanded. Finally, I'll discuss some of the social outcomes of the first 35 farm school graduates who were taught by Kingsley Fairbridge, and I'll indicate towards some of the limits of his institutional power. So understanding institutions like the first Fairbridge Farm School requires some theorising of how people become embedded in ideologies through the medium of language. Martin Heidegger calls language the house of being, which is to say that people think and understand themselves and the world through words, symbols, and other forms of representation received from society. Jacques Lacan theorizes that during early childhood, people become steeped in language through a process he terms the mirror stage. He uses the metaphor of an infant recognizing themselves in the mirror for the first time to reveal how people define themselves in an initial moment of self-objectification as an entity with clearly demarcated limits distinct from other beings and things. Lacan argues that this is how people begin to internalize and construct a sense of who they are, but of course this process goes beyond the first moments of recognition. It occurs throughout life, and psychoanalysts like Erikson recognize that fact. Even so, the self is constructed primarily during childhood, when young brains have remarkable neuroplastic qualities, and they have a corresponding capacity for learning, personality formation, and change. In accordance with this fact, this biological fact of human maturation, and building on Lacan's theorization of how selves are constructed, Louis Althusser asserts that people are gradually interpolated into particular subject positions in a piecemeal way as they cue in on who they are and internalize certain roles and identities based on how others engage with them in social interactions. As such, the self is constructed and remains in a state of perpetual reconstruction as a potential site of ideological intervention, especially in childhood. The formal education system emerges as the primary means through which states can try to instill ideologies. In learning about who one is in a society, a person becomes both steeped in language and embedded in ideology, with the former the vessel for the latter. Through state curriculums, it becomes possible to seek to govern people's very senses of self, to produce certain types of people with a view to reimagining some aspect of a society. Michel Foucault develops this strand of thought through the concept of governmentality, which can be characterized as the governance of people's dispositions through inducing people to self-regulate in desired ways. Essentially, he argues that Western governance has transitioned from medieval systems, which primarily exercised power by punishment and by extinguishing life, to a system in which states primarily govern by trying to control what people want to do or can imagine doing in the first place. That is, by regulating their conduct, their morality, and by extension, their lives. Foucault notes that the advent of widespread institutional education made it possible for aspects of morality and indeed of personality to, quote, be administered like trade or economy by the state. Nicholas Rose, in his work developing the concept of governmentality, asserts that childhood has become, quote, the most intensively governed sector of personal existence. As Patrick Ryan has observed, modern states largely govern through intervening in people's lives during childhood in order to shape people's dispositions in such a way that they become the economic and political actors that local circumstances demand. So when the Fairbridge Scheme was approved in 1911, childhood was becoming increasingly distanced from adulthood. In the late 19th and early 20th centuries, children were largely expunged from the workforce, and Australia legislated for compulsory education. As adults and children increasingly occupied separate spheres, these two categories of adulthood and childhood came to co-constitute one another, as children were thought of more and more as future adults, and adult personalities were essentialized into childhood experiences at the discursive level. Australian political scientist Stana Nakata argues that this way of understanding childhood has led modern states to govern children by seeking to shape them into certain kinds of imagined future adult citizens. Rather than recognizing the child as a current political or economic actor, states emphasize that children are in a state of becoming and focus on developing who the child will become when they're grown up. As such, in the 20th century, in children's homes where inmates lived separate from societies, state programs like the Fairbridge Scheme sought to displace the family as the primary source of socialization, thereby seeking to configure certain cohorts' identities in a more totalizing manner by determining their conditions of existence in quite complete ways. I'll move now to the settler colonial project in southwest Western Australia, to which Fairbridge's first farm school would contribute. British colonisation of the region began in 1829 with the first 300 settlers of the Swan River colony intruding on Noongar land. The colony grew significantly between the 1850s and 1880s when almost 10,000 convicts were transported from Britain. And then in the 1890s, the gold rush fundamentally transformed southwest Western Australia, with over 430,000 people arriving in the 30 years after 1898. Yet despite the gold rush and the huge settler majority it established, the physical occupation of Noongar land by settlers remained incomplete. Southwest Western Australia was peppered with abandoned farms and arable land uncultivated by settlers. Between the 1910s and 1930s, a number of state-endorsed settlement programs seeking to address this would go on to fail. And it's in this context of the existence of a stranded urban settler majority that the state endorsed Kingsley Fairbridge's scheme in 1911. The Western Australian government desired white farmers and farmhands who would work the land and stay on it, and that's precisely what Fairbridge's initiative was geared to achieve. From the time when he started to lobby colonial elites in 1908, Fairbridge's project was configured to secure 2 out of 3 of the factors of production, land and labour, in such a way that could simultaneously supplant the need for Indigenous labour and attempt to replace Indigenous claims to the land in whichever British colony would support the scheme. Fairbridge's idea was for his institution to start out as a series of small farms expanding outward year on year, such that eventually 1,000 children could spread over 5,000 acres. In other ways, Fairbridge aimed at an almost endless growth, stating in 1910 that the institution's, quote, functions in respect of one locality would not be permanent, but would cease to operate as the district became more thickly settled. After 20 or 30 years, a farm school would sell its improved lands and the nucleus would remove to a less populated district and begin again. Newfoundland's government even entertained supporting a farm school that would expand until the whole island is transformed by the children's influence. In spite of Fairbridge's ambitious plans, though, he would not have it all his own way. The Newfoundland government ultimately wouldn't fund his scheme. Rhodesia had already turned him down, and when the New Brunswick government also declined, it was the Western Australian government who offered tax exemptions, limited grants, and an abandoned 1,000-acre farm at Pinjarra, south of Perth. Fairbridge was able to establish the institution in 1912, with the first children arriving in January of 1913. However, the following year, the First World War broke out, and much of the institution's funding, as well as all its potential new wards, were no longer to be sent from Britain. Even when frustrated and underfunded in 1918, Fairbridge retained his lofty ambitions for his farm schools, though. He wrote that there is ample room in Western Australia for, There is ample room in Western Australia for 3 farm schools, each holding 200 boys and girls, and the other states of the Commonwealth could find farm and domestic employment for the trained youths of another 15 similar farm schools, providing a total of 3,800 immigrant children in course of training in Australia. Of these, about 630 would be leaving their schools every year. In terms of how to bring about the social changes he desired, Fairbridge thought deeply about the possibilities of shaping people during childhood. In 1910, he published a long-form article with a section titled Heredity and Environment in the Empire Day special edition of the Times. In the article, Fairbridge consulted the evolutionary theories of Charles Darwin, Jean-Baptiste Lamarck, and Auguste Weismann in order to debunk the, quote, very widely, though unconsciously held assumption that acquired characteristics are inherited. He believed instead that the fact of human learning is the immutable principle of character formation, and he therefore wanted to, quote, surround our children with good ideas with sound examples. He concluded that the children of slum parents are not born with the characteristics derived from slum life. They acquire them as they grow up, and if transplanted young into a better environment, will not develop them at all, nor will their children in turn. For these reasons, he stated that the emigration of adults to the colonies was merely performing the function of an employment agency, dealing with humanity that has had its chance of learning. With children, he asserted, it is quite otherwise. The scheme's discursive foundation thus rested on the double construction of the slum child as a blank slate, co-constituted by their imagined future as a mutable social risk. Fairbridge feared that poor parents would squander their children's potential, observing that, quote, ignorant rich men have nurses and doctors to look after their children and keep them strong and healthy, but ignorant poor men have not. Consequently, their children suffer or perish. Fairbridge considered that children's, quote, direct contact with the derelict workhouse inmates means that by the age of 35 or 40, these once promising little boys of ours are heartbroken, worn out, useless human derelicts. Through education, Fairbridge targeted the children's mentalities, seeking to shape, to use his words, thought and word and deed. This he sought to effect through timetabling the minutiae of the children's days. 2 hours of studying agricultural theory, 2 hours working on the farm, reading Kipling in the evenings, boxing in the afternoons, and so on. Each task and expectation was codified and dictated with precise detail, whether placing tools in the correct spot, closing farm gates, or squeezing the cow's teats dry. Through timetables, codes, and lists, Fairbridge sought to micromanage the children into becoming loyalist colonial farmers who would embody his vision of a robust British population that feels at home in the Australian countryside. His specific intention for shaping these children was to establish a tripartite connection between the individual, the land of the colony, and British identity. He intended for the children to come to, quote, love the land and thus keep to the land. At the same time, he intended that, quote, we must see that our empire is peopled with Britishers, with those who can understand the meaning of empire and can look back on Britain as the motherland. To these ends, Fairbridge sought to impose a morality which he intended for the children to, quote, imbibe through the books they read, from the personality of the staff, and from the whole order of things about them. But he also wanted to teach the children practical skills of working class people with little disposable income. That is, how to, quote, sew on their buttons, wash their own faces, and cook their own meals, make their own clothes, grow their own food, build their own log cabins, and train, exert, govern, and educate themselves in every department of daily life. The children were encouraged to display deferential behaviour towards employers and to stoically accept abuse. In this way, the farm school taught subservience, frugality, and the acceptance of poor working conditions, which could benefit the third factor of production, capital. Fairbridge's institution embedded the children within a system of thought that positioned them as both colonisers and as subservient working class citizens. Within the desired construction of selves were two opposing imperatives of settler colonisers' identities noted by Lorenzo Veracini: the need to establish a connection with the metropole and that of self-indigenizing, to feel at home in the colonised land. From the scheme's inception, Fairbridge stressed the desirability of emulating the Boer settlers who were, quote, not only in the country, but of the country of South Africa. He believed that after his farm school training, the children's, quote, hearts will become wedded to the soil, and there is a very good chance of them sticking to the land as their life's work. In this way, Fairbridge wanted his wards to become at once definitively British and somehow indigenised in their land of adoption. So I'm going to use the case study of these three boys sent over from Miss Crowell's children's home in Scotland in 1913. Robert Dixon on the left quickly learned at the farm school that he hated farming. He moved to Fremantle, where he found work on the docks, and he worked as a civil engineer until he fell to his death at the age of 63. John McPhee in the middle found work on a farm in Albany in 1919. In spite of being described as a popular young man, his correspondences at this time paint a lonely and despondent picture. He clung to memories of his sister, who he left behind at the children's home, and he framed a picture writing that, quote, if she were to die, I would go too, although I haven't seen her for many a long year. Kingsley Fairbridge tried to put McPhee in touch with his sister, but the children's home elected to keep the two apart, and McPhee's sister's only vague recollection of him later in life would be of their holding hands at Miss Crowell's children's home when they were little. McPhee moved to Queensland, then New South Wales, before enlisting in 1940, and he became a prisoner of war in Singapore and ultimately was one of the 12,000 Allied soldiers to die in the construction of the Burma-Thailand Railway, also known as the Death Railway. John Duncan on the right received poor treatment while placed on a farm in the Western Australian wheat belt at the age of 14. He was fed scraps and forced to sleep on the floor of an outhouse and was not allowed to enter the main house at all. He saved his half wages though and moved to Melbourne as soon as he could, where he became a master butcher, and he eventually started a catering business in Adelaide. So these three cases were not exceptional, but nor was that of Horace Britton, who appears to have emerged from the institution with debilitating emotional scars. He had a breakdown in 1924 before he had another breakdown the following year and was institutionalized, as were about half a dozen of the first boys. He died at 49, bitter at the government's treatment of him, according to historian Angela Sherry. And Sherry's study of the first 35 children at the farm school has revealed that most of them relocated to urban settings in the eastern states, with just one becoming a successful farmer for a time before going bankrupt. Although a number worked as farmhands for some period, by 1960, just one of the boys actually worked on a farm at all. In spite of Kingsley Fairbridge's totalising attempts to determine the characters and economic futures of the children in his care, each and every one of them rejected his vision for them, failed to accumulate the capital to be a successful farmer, or died at war. So returning briefly to the moment when the first children arrived in January of 1913, many were reduced to tears and did not appear to have a normal appetite. Fairbridge wrote to the colonial elites who supported his scheme, saying that there was anger and ill feeling among the boys. The smallest had even bitten another boy. Ultimately, Fairbridge was only able to manage the children's aggression by allowing them to box each other every day at 3:30 in the afternoon. Unable to sunder the children's violence, the best he could do was to reconfigure it. And the oral history testimony of Tony Holmes attests to the children still boxing each other in the 1950s, with the elder children arranging mismatched fights between the younger children as a form of bullying. The Fairbridge scheme was configured to exclude, in Fairbridge's words, the derelict, useless person that the poor British children appeared to have been destined to become. At the same time, the institution worked through the positive production of desired identities. As can be guessed, the former function was more successful than the latter. The influence of family, even a poor family, in a person's life cannot be reduced to an environment that entails social risk. One of the themes that recurs in the oral history testimonies is the sense of loss of family, as well as the sense of having lost the life the interviewees might have had and the person they might have become. I'll just skip through a little bit here as it seems I'm over time. Although Fairbridge fundraising paraphernalia would one day boast of having turned out 1 in 400 of the settlers in Western Australia, the value in analysing this eugenicist modality of settler colonialism does not lie in the scale of its impact. Its value lies in understanding it as a disquieting capitalist innovation, and in its analysis as an other space, a farm school which contains a refracted image of the society beyond its bounds. It is an entry point for understanding the lengths to which British and Western Australian governments were willing to go to try to establish dominance on land contested by Indigenous people, for understanding the variegated modalities that it takes to establish a settler society, and for understanding a scheme that would make unwitting children at once the beneficiaries and the victims of Australian settler colonialism. And in the end, the institution's focus on repressing metropolitan urban subjectivities functioned as a ruse of power. The decisions of many children to reject the agricultural life that Fairbridge sought to determine for them provided the semblance of an escape from institutional control, but almost all the children remained in Australia, and as such, they did not escape the settler colonial structure. Thank you. And sorry for going over.
Thank you, Tim. Okay, so I'm now going to direct questions to the panel. I have a question here. Now, some of the questions have been asked in the chat function and been answered by the panelists as we've been going along. There's a question that's been put here by Joanne Faulkner for Tim. She's very interested in the phrase you use, excluding the person the child was to become. And Joanne writes, I'm interested in the interaction between the purpose of Fairbridge's farm school and the institution set up for Aboriginal children of mixed heritage who were also supposed to assimilate into the settler coloniser community as farm and domestic labour. So her question is, were the functions of these cohorts discussed in relation to one another by politicians, bureaucrats or philanthropists, or were they parallel developments?
That's a really great question. And frankly, I learned a lot of the things I know about the philosophy of childhood from Joanne Faulkner's writings, etc. So I'm also mildly starstruck. But I would say that I initially developed that phraseology and that theory doing research on Aboriginal children with mixed heritage. And then it wound up applying to this as well. So in terms of, I guess, the discourses crossing each case, like from the stolen generations kids to the child migrants, you do have some overlap for sure. For example, A.O. Neville obviously is this incredibly influential figure in Western Australia as an administrator who administered the so-called half-caste and quadroon legal categories, and he's basically synonymous with the stolen generations there. He also was involved with the Fairbridge Farm School the first, just as an inspector, and he very much approved of it. And anyway, he wrote explicitly that he really liked it after the inspection. In terms of having the same people actually defining and campaigning for the schemes, perhaps I haven't seen as much evidence of that, but that could be my limited knowledge. That's not to say that it didn't happen exactly like that. But in any case, thank you, Dr. Faulkner. I think you're muted, Ruth.
I'm muted, sorry, yes, okay. I had a question actually for Luara. You've been having a little bit of discussion here with Kaz on the chat function, but I just wondered if you wanted to respond to the current situation with borders now in terms of citizens being locked out of Australia, and how, what would be the liberalist response to that situation?
Yeah, so unfortunately, can you hear me okay? It feels like I'm frozen. Okay, good. Yeah, so in the book, I also explain what I think is valuable about citizenship, and my account of citizenship has it that what's valuable about citizenship is that it provides or gives us reliable access to core rights. One of them is the right to return and stay in the state where you're a citizen of. So I don't think the government can justify the exclusion of Australian citizens or the closing the borders to Australian citizens. I don't think you can appeal to any good liberal argument to justify that. Yes. Okay. So of course, Australia doesn't have to be a perfectly just society to count as a liberal society, right? The question is, do we realize those values to a sufficient degree? If so, we have a right to self-determination. We have a right to pursue our own political future. But it's not like, when it comes to a conception of the good, where as an individual, I can do things that are harmful to myself. I can, when it comes to a political community, when it comes to this political future, there's room for experimentation, and there's room for a community to figure out what it is that they value. But there are there are constraints, significant constraints in what they can do. So a political community is much more limited in what it can do together, but they should have some space to figure out within those constraints of liberal values, what it is that they want to achieve as a community.
Interesting. Yes, it's very interesting hearing this from a philosopher's perspective, a political philosopher. It's quite challenging for a historian to engage with these ideas. And look, I just had one question for Matt as well, and it's not a very well thought through question, but you've been talking a little bit about language in the chat, and one of the things that we hear a lot from, is that excluding people based on the cost, the burden of cost. And I just wondered if you could sort of discuss that a little bit more, how you balance cost with social or community good and benefit.
Sure. So there have been a number of studies that have tried to look at the benefits of different types of migrants in various ways based on their education and background and the like. And one of the ideas that's often said is, well, we want to bring migrants to the country who will be beneficial to the society overall. And that's usually put in, in a quite reductive way, but that they would, over their lifetime, contribute more or pay more taxes than they would use in services. And then, I mean, that there's lots of complications and difficulties in trying to figure out how you measure that type of stuff. But people who are economists make some estimates on this, and then it's big, broad strokes. And you think, well, that's a pretty reductive way to look at things. But you think, well, what could possibly justify that? And one of the things you might think is a sort of degree of reciprocity. So if we followed Luara's idea, which I more or less agree with, is that there's no sort of general obligation to allow in anyone who wants to come to a country to come to it. You would say, well, we'll allow people who in some ways are beneficial for us. And one way would be is if you're going to expected to be a net contributor, then it's harder to say, well, we're going to keep you out just because we don't like you in some ways. Now, one difficulty of that is, of course, that it's not clear that these are the only grounds for deciding that someone's a benefit to the society. One of the things that's interesting in the Australian cases, not in the Migration Act, but if you look at the regulations, it indicates that emotional ties are not supposed to be taken into consideration when you're deciding whether someone is going to be a burden on the society or not. So when you imagine an Australian citizen has married a non-Australian and that person has a child and that child is disabled, but they all love each other and whatnot, and it would be quite bad to separate this family. But we're not supposed to take into consideration the fact that these people are a family, they love each other, they would care for each other. That seems pretty reductive to me. And I think that's sorts of stuff that we should look at and consider more carefully. We also should consider more carefully about what types of contributions people can make and what it says to the current members of the society when we exclude certain sorts of people. If we say, well, look, if we're going to exclude disabled people, what does that say to the disabled members of society? And I feel somewhat nervous about those types of arguments. I'm not completely sure what to make of them. But especially when it's the state, seems to be the state speaking, I think that's something that we have to take into account on it. Not sure how far that gets to your
No, it's
issues
an interesting discussion. Yeah, and I've been looking at what's the sort of discussion that was occurring in Canada around this issue too.